Good afternoon, everyone. Belt and Road involves legal work in different jurisdictions within the Belt and Road diaspora. And today, I would like to provide you with the overview of force majeure concepts under Russian civil law and Myanmar common law. In such challenging times, enforcing a force majeure rule may be the only option available to the affected parties. Businesses affected by natural disaster, war, protest, and pandemic may avoid obligations without being in breach of contract under existing contracts through recourse to statutory provisions or force majeure provisions in the contract itself. There are generally three essential elements of a force majeure event: occurring with or without human intervention, not reasonably foreseen by the parties, and beyond the parties' control and consequences, which could not have been prevented. In common law countries, there is no general legal concept of force majeure. Rather, force majeure is a creature of contract. In English common law, it is generally understood to mean an event or circumstance that occurs and which prevents one or both parties to the contract from fulfilling their obligations under the contract. In civil law countries, force majeure is directly regulated by civil codes and acts as a legitimate ground for non-performance or not full performance of a contract. Speaking about civil law countries, we can look closer at Russia, where Civil Code in Article 401 provides that an event qualifies as a force majeure if a party is able to prove that the performance of the obligations has been impossible due to the event simultaneously having the following features: emergency and inevitability. Under Russian law, the decision as to whether an event constitutes force majeure is made by the court on the request of the party claiming relief for force majeure. From the legal perspective, the official position of the executive authorities does not bind the court, although it might be taken into account along with the other evidence. Russian law allows for the terms of contracts to provide for rules that differ from the rules established by default by statute. Therefore, when considering whether there are grounds for release from obligations or liability, the provisions of the contract must be considered first and foremost. Moreover, Article 401 of the Russian Civil Code expressly states that the following are not considered force majeure: default by subcontractors or other counterparties on which a party to a contract relied in order to perform its own obligations; the absence of the market of goods required for the performance of obligations, or the party's lack of funds. Although the term pandemic or epidemic is used frequently in contractual provisions of force majeure, Russian law does not have a clear answer as to whether the epidemic shall be considered a force majeure event. Importantly, as it was recently clarified by Russian Supreme Court, the pandemic itself cannot constitute a force majeure event. Only specific consequences of COVID-19, such as raw material supply shortages and government lockdowns, would constitute a force majeure. In many cases, the default would likely be caused by several factors, such as restrictions related to public events, transportation, export of certain types of goods, etc. Thus, if the list of force majeure events in the contract includes a pandemic or an epidemic, this would simplify the process of providing that events due to the COVID-19 qualify as a force majeure event. In any case, the party will be required to prove that the event has met the above tests. Now let's have a look at Myanmar's approach. The legal system in Myanmar is based on English common law, and as mentioned before, there is no generic definition of force majeure in common law. Rather, it is a matter of contractual interpretation in each case, and the defaulting party must prove that one of the events referred to in the force majeure clause has occurred. They have been prevented, hindered, or delayed from performance by that event. Non-performance was due to circumstances outside of their control, and there were no reasonable steps that could have been taken to avoid or mitigate against the event. In Myanmar, this common law concept of force majeure is governed under Section 56 of the Myanmar Contract Act. The section adopts the English doctrine of frustration. This doctrine provides that a contract may be terminated on the ground of frustration when something occurs after the formation of the contract, which renders it physically or commercially impossible to fulfill the contract or transforms the obligations to perform into a radically different obligation from that undertaking at the time of entry into the contract. Force majeure clauses in contracts and the stipulations under the contract may differ from case to case. There may be force majeure clauses where, upon continuation of the force majeure event beyond a certain number of days, would automatically lead to a termination of the contract. In most contracts, the affected party wishing to enforce a force majeure clause must send the notice to the other party within a specified number of days from the occurrence of the event. Depending on the nature of the case, the contract may be terminated, or an extension of time will be granted to perform the contract upon the force majeure event ending. As many other countries, Myanmar has imposed various measures to curb the spread of COVID-19 that has consequently resulted in difficulties for businesses to perform contractual obligations. Can parties in Myanmar rely on a force majeure clause that allows for non-performance of contractual obligations without frustrating the contract? The answer depends on whether the contract contains a force majeure clause and whether the clause covers a pandemic event such as the COVID-19 outbreak. However, if the parties wish to enter into a new contract, specific attention should be given to referencing the COVID-19 pandemic. Indeed, the evolution of the pandemic is now not unforeseeable nor unpredictable, and could likely not be claimed in good faith as a force majeure event, given that the parties would be aware of the pandemic at the time of signing of the contract. That's the end of my presentation. Thank you for your attention. Have a great day.